Another lawyer weighs in on the ACC and Florida State lawsuits.
Conference realignment is always in the news, so we're back on the big mountain to keep you updated.
Hey, it's great to have you here on the mountain. If you're new to the channel, I am JY. This is my good friend Steve. If you're new, you might be wondering what the heck's going on behind us. We've got balloons up here saying celebrate. We just hit our 1,000th subscriber in 5 months. We are celebrating that. We thank our subscribers. We thank our viewers. And Steve, we're going to dive into the ACC and FSU lawsuits. I found an article from an attorney with Darrow Everett. I am not going to try to pronounce her name because it's a very difficult name to say, but these offices are on the East Coast. They do have an office in Florida. They do have an office in North Carolina. And this article was from December 29th, 2023, so only a few weeks ago. And she brings up three kind of legal issues, challenges. One of them in terms of the restraint of trade. We've heard a lot about that. One of them in terms of the unenforceable liquidated damages. We've heard a lot about that. And the last one, I teased this and kind of gave the answer away a little bit on our previous episode about where's the case going to be heard, the jurisdiction in terms of where the case is going to be heard. So let's go through all three of these. This won't be a super long episode, but I wanted to give her take on where it's at. Clearly, you're going to have another attorney that would disagree with this. I like what you said in one of our episodes. You get 12 attorneys in a room. You'll have three that say, it's one way. You have three that say it's the other way. And you have three in the middle saying, well, it could be either one or the other. I would say right now she's probably in the middle, just kind of potentially poking holes at different things, seeing some potential avenues where, Florida State maybe does have a legitimate challenge to some of these things. So let's start with the restraint of trade. FSU claims that the ACC's hefty withdrawal penalties, in their minds, upwards of $572 million, violates the Florida antitrust law that says that any restraint on trade or commerce is unlawful. FSU claims that the penalties prevent it from competing in the marketplace to attain best terms. The market being that of college athletics and media rights. The firm states that a problem with this claim is that the section they are using is concerned at protecting the public from harm to competition, not the protection of individual actors, as they call them. Stating a Florida case, the Capital Wealth Advisors LLC versus the Capital Wealth Advisors Incorporated, the court ruled that antitrust laws are not implicated where a contract later turns out to be financially unfavorable to one party. And that is the deal that they agreed to and in which they operated under for some time. So kind of using that here, she's saying, hey, this is an agreement that you operated under. You've used it for some time. The actions, words type of thing. Mm-hmm. She didn't state that, but we've said that before with our good boy, Judge Levy, out in the Pac-12 issue. So she's kind of, talking about that, but also saying this is protecting the public. Now, I'm going to hear what people say. I'm going to preempt comments. Florida State University is a public entity. The public is behind the public entity. Okay, I get that argument, and I'm not here to poke holes in her argument. But hey, I just put three comments out there that I know we would get, and I know that's what some people would say to this. Finally, she says, while withdrawal penalties may be a substantial financial disincentive to withdraw, that does not make them a restraint of trade in her mind. The second piece. Unenforceable liquidated damages. One where she feels there could be maybe some issues here that FSU could take advantage of. The penalty, the $572 million, may be deemed an unenforceable penalty because it bears no reasonable relationship to the actual damages suffered by the ACC. This definition is found in Florida law. The non-breaching party cannot have a windfall. They can only recover the actual damages pled or proven at trial. ACC's claim that FSU knowingly and voluntarily entered into the grant of rights and is stopped from challenging its validity does not hold up against the law on liquidated damages both in North Carolina and in Florida. Courts must determine if the liquidated damages proportionate or disproportionate to the harm actually suffered from a breach. I'm just going to put a note on this. While the original ACC filing did not include any sort of validity of value, the amended did include, and they added some in terms of what that looks like as we can kind of unravel this. Now, I'm not saying it goes to the $572 million, but we did talk about back in 2012 that they had a media rights consultant that gave an estimate as to what a member's worth was, and it was that $130 million withdrawal penalty, the severe withdrawal penalty within the Constitution. It fell right in between the range they gave for a member institution over that time. So I kind of agree with this. I mean, clearly, well, I do agree with this. You know, you can't have, the ACC can't have a windfall of money over FSU or any member just because that's the number they feel like charging them. You know, it has to be tit for tat. You know, if they're giving up something, the value of that something needs to be determined. They need to describe what that is, and that's the value they get out of it. It's not an arbitrary number, and that's kind of what she's getting at. Now, I will say, and I'll turn it over to you, the ACC is going to back that number up.
Yeah,
they will. They'll try to. They'll try to. I'm not going to say it's going to be worth much, but they will try to back that number up to combat this question. Right. So, anything on that, Steve?
No, I think you should keep going.
Actually. Okay, last one. I kind of teased this one and gave it away. The third, the forum. Where will this case be heard in terms of jurisdiction? I want to point out here first, the ACC stated that FSU is subject to North Carolina law. That was in their lawsuit. However, this contract does not have a choice of law provision, and that's huge. It should have been in there to answer this question. It's not in there. And this is kind of odd based on what we're talking about here. Like, we're talking about an entity that has schools within a bunch of different states. So to not address this in this choice of law provision, in my business, I deal with a whole bunch of different contracts. This is almost always in there. Now, for me, you know, it's not just the state we're going to do it in. It's actually in the county that we're going to do it in. Because, you know, we might work with people from all over the state, and they say, hey, we're not driving across the daggone state to hear something. This is going to happen in our county. And it actually, you know, specifies the county that this is going to be in. So, you know, again, just to go back to what she said that the North Carolina filing would take precedent. There would be a stay on the Florida filing until the North Carolina filing is heard and whatever comes out of that. Obviously, a stay doesn't mean it's not going to be heard in Florida. It just means
it's a pause.
It's a pause until they hear the one. So, you know, I maybe punted on that. Not punted, but maybe didn't give the answer some people were hoping for. But that was kind of her take, is that the Florida case will be stayed. And she said this is pretty similar to what you see anywhere, that they'll stay the one case in favor of the case that was put out the first time. So that's where we're at, Steve. Yeah. Anything there?
Yeah, so I got some comments. So first of all, just for our audience, we want to say again, because there might be some people, this is their first time seeing us, watching us, or just seeing one of our episodes talking about this particular matter. We want this to be an ongoing discussion and dialogue. We're not trying to crack this whole case in one episode. We're not, you know, if you're looking for someone to give you an end-all, be-all judgment on the merits of the case, that's not what we're trying to do.
Well, and I don't think that's out there.
No.
In any sort of good faith, that's not out there.
Absolutely. But you will see a lot of people out there that are in their corner. They find something that one lawyer said or one other person said or whatever, and they run to that because it validates their own opinion, whatever.
Sure.
And they kind of just grab that by the horns and they ride it until it dies, kind of thing.
Yeah.
That's not what we're trying to do.
Right.
We want to engage in an ongoing conversation. And yes, when we first started talking about this, I made the point of, you get 12, and I've seen this happen in my professional, I work in kind of in an area where government and higher education intersect, and I've done this before where you get in a room with 12 lawyers, 3 of them will say, you know, A is absolutely correct, 3 of them will say B is absolutely correct, and the other 3 will say, well, it's a big muddy mix, and it could be this or it could be that. So that's what my expectation in this, and I want to just continue that discussion. We enjoy having this discussion. We love when we get those constructive comments from our our listeners, our audience. And in fact, there was a couple people that suggested a couple different articles to us. So we're going to do another episode on one of those articles. So I love it when they bring those to us. I love seeing different viewpoints, and we're going to continue that conversation. The second thing I will say, there was a lot of good stuff in there, but I think that last part is actually huge. Okay. Yeah. I know there's some people that they wanted an answer. Who has jurisdiction? Does North Carolina have jurisdiction? Does Florida have jurisdiction? There's not going to be an answer to that yet. And in my mind, what we talked about before, I think ultimate jurisdiction is going to be a federal court because I believe this is interstate commerce. However, North Carolina or ACC was smart to get their lawsuit out one day in advance in North Carolina. That's where they want this to be held first. It's actually I think it's pretty important to go first in this, okay? Because here's why. And we talked about this a little bit on the other episode. If Florida State is allowed to go first in the state of Florida, in a county just that contains Tallahassee, I believe, and they get a favorable ruling right away, I think you're going to see the power players in the state of Florida move, the governor, the attorney general, to say, boom, this was decided. This grant of rights, this contract is unenforceable in the state of Florida. Yeah. It's illegal, and they're going to move forward right away. And that's gonna be a very powerful thing. Mm-hmm. If the ACC can, if they can, because this is what we're talking about right now, is who gets to go first kind of thing. Yes. If they can go first in North Carolina in a friendly court, they can make their arguments, whether they get a favorable ruling or not. They can make their arguments. They can put that out there and basically give themselves some time and some space to make their case and to establish the merits of their case. Yep. I think that's huge because I think the biggest danger to the ACC is in the state of Florida, the governor, the attorney general, the powers that be getting involved because it can start that chain of events we talked about. Yeah. I really think the ACC's main goal is to limit the damage, limit the financial damage, and limit the amount of schools leaving. Yeah. And if this gets heard first in Florida, the state of Florida, that could start a chain of dominoes going down where 3 weeks later you could have half the members leaving the conference. Right. Mm-hmm. So I think it's huge. I'm glad you pointed that out of that article because I think it is hugely important if that doesn't in fact happen where North Carolina ACC gets to go first in North Carolina.
According to her, that's what she says.
We'll see. Yeah, I want to make one other point. Yeah. You did say it was very interesting how they didn't didn't have the
choice of law provision.
Yes. Yeah. And I wonder, it could have just been an oversight. Okay. I kind of have trouble accepting that it's an oversight because they've been so thorough with this. The grant of rights had so many lawyers. I really wonder if it's a case of the different schools. We talk about a lot of state universities could not agree on a choice of state law. So maybe that was intentional and there was just not agreement because the state laws do differ so much. Right. And for 2 or 3 states to say, oh yeah, it can be heard in another state that has different laws from us, and we're a public institution. We are governed by the laws of our state. That could be hard. And so for you were talking about with your job in the counties within the state. Yeah. It might be different if you had a contract outside of your state. Yeah. And for you to go into a contract, you may not want to do that, where you could go into a contract that could basically violate the state law that your entity that you work for is in. So anyways, long-winded way of saying that might have been intentional.
That is an outstanding point because I've heard people picking at this saying, this is basic law. This is basic practice. Like, how would they miss this? They're dumb for missing this. Yeah. But that right there is a great answer as to why. I don't know if it is the answer, but it makes a lot more sense for me to say that's the answer than to say, oh, the ACC lawyers are dumb. Right. Because I'm pretty sure they're dumb.
Not, and they've worked so much on this.
Right. So that really, really strong point there,
Just a guess by me.
Hey, that's what we're all doing right now. That's what we're all doing. And as I said, you're going to get people that think they have this figured out. To go back to that comment, I mean, you'll find people out there that say, yeah, this is how it's going to be, and I'm right. Nobody's right and nobody's wrong right now, right? Like, and I know we have some commenters that are pretty strong in their opinions, and that's great. We love that. we do ask that you be respectful. Yes. We sometimes get a little excited, and I get that. We're not in the heat of this. We're not Florida State fans. We're not Florida State alumni or didn't go to any ACC schools. So I get that there's emotion. We saw a lot of that with the Pack, and we totally get that. That probably makes it a little bit easier on us because we don't have the emotion to go in there, a lot easier on us because we don't have the emotion to go in there. But some really good counterpoints there, Steve. And I just want to say, so you mentioned the article from one of our, or two of our commenters. We talked about that on the last podcast. That will be out on Wednesday. We're going to do a deep dive in the Harvard Law Review article that was done a few years back, but it's specific to the grant of rights. I'm going to put some information there in terms of what he wrote then and how it relates to what we have going on right now, because it's really interesting to see how that kind of is playing out. A lot of what he said, well, not a lot, some of what he said is the way things are beginning right now. So really interesting stuff. So I'll do a tease on that. That will be out on Wednesday. It's going to be deep. It's going to be heavy. Please make sure you're sitting down when you're ready to listen to that. We're going to do a ton of talking, legal stuff. But I'm really excited for that. And again, I want to thank those two commenters for bringing that to us.
Appreciate it.
It's good stuff. So, hey, with that, we'll wrap this up. Celebration, 1,000 subscribers, onward and upward. We have a lot of stuff planned here for the offseason of college football. Obviously, we're staying on these lawsuits. We have other great stuff planned for transfer portal stuff. I know Steve's going to be previewing kind of an ongoing mini-series, if you will, that we're going to be doing over the next couple months. That we hope to get that preview out the end of the week. And with that, hey, we'll see you next time on the Big Mountain.
Let's keep the conversation going.